Hi, my name is David P. Shapiro. I'm the owner and managing partner of the law office of David P. Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. In this video, I want to talk to you about what should you be doing if you find yourself in a situation where the cops are telling you one thing and you know that that's not true. And it could be pretty much anything under the sun, but whether or not you are either on probation, and because of that probation status, do you have what's known as a fourth waiver or a Fourth Amendment waiver? Okay, so basic primer on Fourth Amendment rights here. Your right to be free from unreasonable searches and seizures, right? So cops could search your car if they have probable cause, right? When you're on probation, fourth waiver. And a fourth waiver will enable a law enforcement official to search, whether it's your car, your body, your house, whatever the case may be, without your consent, right? If they get your consent, it's just another reason to enable them to search. And basically they're going to say, well, as a condition of your probation, you in fact consented to the search condition. And then they'll be allowed to search you, right? They won't need a warrant. They won't need probable cause. In essence, your probation condition or your parole condition is the what happens if you find yourself in a situation where you know for a fact that you're not a Fourth Amendment waiver, that you're off probation, you're off parole, the pending case against you where you might have had a fourth waiver as a condition of your bail is gone? What do? Right? Cops telling you, hey man, that's great that you're saying that, but our records show otherwise. Just keep letting them know. Tell anyone and everyone that'll listen. And even if they won't listen, officer, I'm not a fourth waiver. Officer, I'm not a fourth waiver. I'm off probation. My probation ended whenever it was, right? You don't want to start making stuff up. You don't want to be dishonest. You don't want to volunteer additional information that's not really relevant to the issue. But you want to let it be known and not be complacent and like, oh, all right, they're saying that. Maybe I am, right? Here's the situation. We had a case at the firm in 2021 into 2022. Long story short, the case ultimately was dismissed in October of 2022 based on the work that we did filing a motion to suppress evidence in September of 2022. And a lot of people, when you file a motion to suppress evidence for an improper search, the knee-jerk reaction is, well, what are you talking about? If they think he's on fourth waiver, if they think your client's a Fourth Amendment waiver, the cops are going to say good faith, the DA is going to say good faith, even if it's a mistake, judge is going to say good faith and sorry, your motion's denied and the search is good, right? And a lot of people said that. At times we were skeptical ourselves. We filed the motion. We researched the issue. We distinguished and found parallels between from bad case in our case and good case law as it relates to the cops should have done something more if they're getting conflicting information. So we challenged the search. We said, obviously, our client did not consent. Obviously, there was no warrant. It was a result of a traffic stop, actually a collision investigation. And when it was all said and done, the judge agreed and said, hey, cops can't be doing this. They need to do more, to do some research, to do some investigation, other than just relying on some inconsistent records that in one breath said Fourth Amendment waiver, but in the other breath, court or a diversion type situation. And the court's like, hey, we can't allow this. There needs to be some sort of a deterrent effect that the cops need to. They could sort of always hide behind, well, we thought he was a Fourth Amendment waiver, or we thought she was a Fourth Amendment waiver, so we searched the car. Sorry, we were wrong, but we're going to search the car, and whatever we found should be used against the client. Well, this court in this instance in San Diego in September 2022, and all the evidence was suppressed against the client, what is referred to as a quote-unquote rolling pharmacy of drugs, right? Now, this is a situation the evidence should have been suppressed. The evidence was suppressed, and ultimately what that means is the district attorney had no evidence left. They couldn't use the drugs that were found in the trunk of the vehicle, so they had no case, and they ultimately had to dismiss the case in October of 2022. Now, this also plays into the factor of, well, what are you so happy about, right? What you got a guy who's, with a rolling pharmacy, quote unquote, driving around town and selling drugs to people, and who knows what those drugs could have been or maybe were laced with. And, what's so great about that? Well, what's great about that is the fact that the law says that that was an improper search. And that's far more than what a lot of people refer to sometimes. Oh, you got your client off on a technicality, right? Well, we're enforcing the law in many ways, right? The same way the cops are actually supposed to be enforcing the law. Arguably, sometimes the attorneys and defense attorneys need to be quote unquote law enforcement, in the sense that when the cops screw something up or the cops don't do enough, right? We as defense attorneys need to raise that issue so a judge could look at it and say yes or no. And the hope is, quite frankly, is that the cops still don't, that they avoid these issues in the future by doing more, right? We don't want to see people get in this situation. The appropriate remedy in this situation, in the case that I was talking about, would have been to do more, to try and get some records, to potentially try and seize the vehicle and not search it. Maybe they go get a warrant. Maybe they go find out really what the status of the Fourth Amendment waiver or probation is, right? It's not just say, oh, let them keep making this mistake and we keep getting all these cases dismissed. The hope is that as a society and as a law enforcement, they do their job better. They learn from this mistake and they do their job better, right? But if not, a good defense attorney and a good defense team is always going to hold them to that burden, because we have rights as citizens to be free from unreasonable searches and seizures, right? Different story if the client's like, yeah, search my trunk. We wouldn't be in this position. But there's no reason, right? Why would you consent? Well, if you got nothing to hide, what's the big deal? No. I get pulled over. First of all, I don't know what's in my trunk. I don't know if anyone's had access to my trunk since I last left it. I don't know what's there. I'm not, hovering over the officers when they're searching my trunk, body-worn camera or not. Why would I ask? Why would I give consent? You're not being difficult. You're not being deceitful. You're enforcing your rights. And when you enforce your rights, a lot of times good things could potentially happen. And a good thing happened in this case. It was a good result. It was the right result. And hopefully law enforcement will learn from it. And we're very proud of that accomplishment. So in summary, if you find yourself in a situation getting conflicting information from the cops, so they're telling you something is not true, don't be out of control. Don't be screaming, yelling, and disruptive. Just, hey, officer, can I talk to you for a second? I'm telling you, that case is done. I'm telling you it's done. Can you please look into that? Can I please give me some time to try and get some paperwork to show you that? Can we please call my lawyer from that case who can verify it? Let it be known. One of the few instances where you just don't want to be quiet, where you just don't want to shut up and just sort of stay in the corner and be quiet. When you know the information is wrong and they're relying on that erroneous information, speak up. Don't talk about the drugs. Don't talk about what wasn't there, what you knew or didn't know was there. Just let them know they're wrong and let them know why. So if you have any questions about a search issue, a drug case issue involving, whether it's a consensual search, whether it's a search warrant, or whether it's a situation like this video that I talked about where it's like a hypothetical, or the cops believe it's this Fourth Amendment waiver by way of probation, reach out, assert your rights, and then make sure you get yourself a good attorney and a good law firm to represent you. We are just one phone call away. Again, my name is David Shapiro, San Diego criminal lawyer, 619-295-3555.